Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning, focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to answer a question that was posted in response to one of the videos that I have been doing. And so this particular viewer had posted an inquiry: who serves as your successor trustee after both the husband and wife of a joint trust has passed when you don't name somebody? So we will address that in today's video, but before I do, I wanted to invite you to schedule a free strategy session with me at eldermeeting.com if you wanted to discuss any of the concerns that you may have that's particular to you. Okay, so who serves as your successor trustee once your trust becomes irrevocable? Because as you know, it's revocable during your lifetime, and normally you, and if it's a joint trust, you and your spouse or you and your co-trust maker, whoever that person is, you serve as trustees during your lifetime. And then when the last man standing passes away, then the successor trustee will come forward and handle your trust administration, and your trust is now irrevocable, meaning nobody can make changes to it. And the question is, who is that person if you don't name somebody? Because sometimes people look around and they just don't really have a good name to put in place there, and so they don't name anybody as their successor trustee. And when that happens, when there's no successor trustee in the trust document, then we need to appoint a successor trustee. And initially there's a Florida statute that addresses it. It is Florida Statute Chapter 736.0704. And essentially what the statute says is, first, what we will look to is whoever, all the qualified beneficiaries, if you have a couple of beneficiaries named in your trust, we want them to come together as a group and nominate somebody with unanimous support. So everybody has to agree, and who will be the successor trustee, and then that person can serve as the successor trustee. If nobody can agree, or there's a disagreement as to who should be the successor trustee, then the court will appoint a successor trustee. And they may look to who the qualified beneficiaries are and pick the most qualified candidate in their opinion. Alternatively, and most likely, since there'd be disagreement amongst the qualified beneficiaries, the court would just look to somebody in the Florida bar, an attorney that they know and respect, that they believe will dutifully and faithfully and fiscally responsibly administer your trust, and they will just simply appoint them as the successor trustee. And that person, now as a neutral appointed by the court, will fulfill your wishes in the trust administration and handle all the winding down of your affairs and administering of the trust. I hope that this information has been helpful to you. That's why I encourage people to please look and find and name somebody as your successor trustee, because otherwise you'll be left with your beneficiaries have to either be a get-along gang and have an agreement, or the court deciding for you, and that might most likely increase the costs of your trust administration. So like I said, I hope this information has been helpful to you. If it has, I ask that you like and share with others, and I do appreciate all your comments and your likes, and I try my best to respond to them when I can. You can also schedule a free strategy session with me at eldermeeting.com if you'd like to talk to me directly. Thanks for joining me.